Yes.
You can tell her to get out the order.
Okay. Okay. Here we go. Go ahead on and get it.
Number one. Holmes, number two.
Okay, Ms. Wimberly, for that first set of chairs, gonna walk all the way down to the end, the first chair.
Frog, four.
Okay, Mr. Holmes, you're gonna sit next to Mr. Wimberly. Ms. Simmons, you're gonna sit next to Mr. Holmes.
All right, your number. Yes. Blackman, number five.
Frogs, you're gonna sit next to Ms. Simmons. Ms. Blackman, you're gonna sit next to Mr. Scroggs. Mr. Walker,
Yes.
you have a seat between you and Ms. Blackman.
Word, number eight. Flow.
Ms. Worship,
Yes.
gonna sit on that first row and that first chair. Mr. Lowe, you're gonna sit next to Ms. Worship. Mr. Godina, you're gonna sit next to Mr. Lowe. Ms. Hebert, you're gonna sit next to Mr. Godina, right there.
Here. You're gonna dip.
Pounce. Okay, Mr. Pouncey. That, Mr. Pouncey, there's a seat between you and Ms. Hebert. Yes, right there.
Eagle. 15. Chevalier.
Ms. Menard, you're gonna sit next to Mr. Pouncey right here on the first row.
White.
And Mr. Hill, you're gonna go down the second row and go walk all the way down to the end. And Ms. DeValier, you're gonna sit next to Mr. Hill. Just follow Mr. Hill. And Mr. White, follow Ms. DeValier. Is there a white? Yeah, sit in the chair right there with the yellow one. That's Mr. White. Ms. Gaines, you're gonna sit next to Mr. White. And Mr. Leonard, you're gonna sit next to Ms. Gaines. Okay. Good morning, good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. I say good morning because we've been in here basically all morning. First of all, I'd like to welcome you to County Court at Law number 2. You have been asked to come to court today to serve as a juror in a criminal case. It is a misdemeanor criminal case. Criminal cases are divided into felonies and misdemeanors. Your felony cases are normally referred to as your more serious type offenses, whereas your misdemeanor cases are normally referred to as your petty offenses. Does not mean that they're not serious. It just means that they're not as serious as a felony case. And when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. Now, your felony cases are divided into 5 categories. We'll start at the top, work our way on down to the bottom. You have the capital murder, first-degree felony, second-degree felony, third-degree felony, and the state jail felony. Now, if a person is convicted of a state jail felony, the range of punishment is minimum 6 months to a maximum of 2 years in the state jail, and a fine that does not exceed $10,000. Now, if a person is convicted of a third-degree felony, The range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine that does not exceed $10,000. If a person is convicted of a second-degree felony, the range of punishment is minimum 2 years to a maximum of 20 years, and a fine that does not exceed $10,000. If a person is convicted of a first-degree felony, the range of punishment is minimum 5 years to a maximum of 99 years or life in the state penitentiary, and a fine that does not exceed $10,000. Now, if a person is convicted of the highest felony, which is a capital murder, the range of punishment is minimum life in the state penitentiary without the possibility of parole or death by lethal injection. Now, as I mentioned to you earlier, we handle misdemeanor cases, so those punishment ranges does not apply. And misdemeanor cases are divided into three categories. We'll start at the top, work our way on down to the bottom. You have the Class A misdemeanor, the Class B misdemeanor, and the Class C misdemeanor. Class C misdemeanors are cases that normally start in the JP court or the city court, and they come to this court. If the person is found guilty in that court, and then they appeal their case and they get a whole new trial in county court at law. Now, with the Class C misdemeanor, the range of punishment is by fine only. We cannot give you jail time. We only can give you a fine that does not exceed $500. Now, the next highest misdemeanor is a Class B misdemeanor, and the range of punishment for a Class B misdemeanor is minimum 0 days to a maximum 180 days, or you could be given a fine that does not exceed $2,000, or you could be given both such fine and confinement. Then the highest misdemeanor is a Class A misdemeanor, and the range of punishment for a Class A misdemeanor is minimum 0 days to a maximum of 365 days, which is a year in the county jail, or you could be given a fine that does not exceed $4,000, or you could be given both such fine and confinement. Now, you have been asked to come to court today for inclusion on a criminal case. Our courtroom hours normally vary. Courtroom hours are normally 9 to 5. However, in County Court at Law Number 2, at 9 o'clock every morning, we have dockets. And a docket is just a list of cases that we have scheduled. For example, we have a jury docket, jury trial docket. We have a pretrial docket, and we have an announcement docket. And I guess when you add all of those cases up, they somewhere in the range of about 50 cases or more. So this morning we had our 3 dockets, and now these are the cases that are left on our trial docket. So since we have those dockets in the morning, our courtroom hours are normally at 1:30 in the afternoon to 5. And so if you are selected, those are our courtroom hours, 1:30 to 5. Or sometimes it may go beyond 5, depending on where we are in the trial. Whether or not you are selected as a juror in this criminal case, you are performing a significant duty or service which only free people can perform. If you are selected, the case will be tried expeditiously, consistent with justice, which require a careful and correct trial. If selected on the jury, unless otherwise instructed, you will be permitted to separate at recess, for meals, and at night. Now, I must administer to you the first of 2 oaths. So at this time, I need each and every one of you to raise your right hand. I will administer the oath to you, and once I administer the oath, please say, "I do." Do each of you do solemnly swear or affirm that you will make true answers to such questions as may be propounded to you by the court or under its direction, touching your service and qualifications as a juror, so help you God? Okay, you may put your hands down. Now, ladies and gentlemen, the law requires that each of you possess certain qualifications before you may be considered as jurors in this case. Also, there are certain excuses and exemptions some of you may wish to claim. First, I would like to determine if all of you possess the qualifications for service on this criminal jury. It is very important that you answer these questions truthfully. If you do not, and the lawyers or I discover this fact after you are seated as a juror, the case could be retried. In essence, a mistrial can be declared. And you may be held in contempt of court and placed in jail up to 180 days and be given a fine that does not exceed $500. Now, the way I'm going to do this is I'm going to ask a series of questions. I do not want you to answer those questions out aloud. Just answer the question to yourself. And then when I ask the last question, I will ask, is anyone disqualified under the law? And if you think that you may be disqualified under the law based on the answer that you gave to one or more of the questions, I'll ask that you raise your right hand. And then we would ask that you will come up before the bench so that we can discuss the matter more privately. When I use this term more privately, what I'm talking about is currently we are on YouTube. We will turn the YouTube off. We will turn on this noise device. And I will also turn off the microphone. Okay. So again, I will ask a series of questions. I do not want you to answer these questions out aloud. Just simply answer the question to yourself. And then at the end, when I ask, is anyone disqualified under the law? You think you may be disqualified under the law based on one or more answers to the questions that I'm going to ask, just simply raise your hand and we will ask that you will come up before the bench. Now, the first question, except for failure to register, are you a qualified voter in Jefferson County and the state of Texas under the constitutional laws of the state of Texas? Have you ever been convicted of theft or any felony? Are you under indictment or legal accusation or on deferred adjudication for theft or any felony? Now, I usually pause before I ask this question. I'm not trying to pry into your personal affairs. I'm just simply trying to ask the questions that we are obligated to ask. And this question is as follows. Are you presently insane or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you a resident of Texas and a resident of Jefferson County? Are you of sound mind and good moral character? Are you able to read and write the English language? Have you served as a petty juror for 6 days in the preceding 3 months in a county court or 6 days in the preceding 6 months in a district court? Now, that was the last question. So is anyone disqualified under the law? If you think that you may be disqualified under the law, please raise your right hand. Okay, we have one. That's juror number 16. Okay. Let's see there. Is there anyone else on the panel who think that they may be disqualified based on your answers to any of these questions? Okay, there's no one else. So now I will proceed to exemptions. I will determine if any of one of you who is otherwise qualified to serve as a juror wishes to claim any of the following exemptions. You may claim any of the following exemptions if you choose to, but you're not required to claim them. If one of these applies to you, but you still desire to be considered as a juror, just remain seated. Okay, and now I would ask these next series of questions in the same manner that I asked the previous set of questions. I do not want you to answer these questions out aloud. Just please answer them to yourself. And if you'd like to claim an exemption after I finish asking the final question, I would ask, is there anyone who would like to claim an exemption? If you'd like to claim an exemption, based on your answers to the questions, then we'll ask that you will come forward. First question. Are you over 75 years of age? Do you have legal custody of a child or children under the age of 12 years? And jury service would necessitate leaving the child or children without adequate supervision. Are you a student in a public or private secondary school? Are you enrolled and in actual attendance in an institution of higher education? Are you an officer, employee of the Senate, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a petty juror in the county or in Jefferson County during the past 3 years preceding this date? Are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? And this is the last question. Are you a member of the United States Military Forces serving on active duty and deployed away from Jefferson County? Is there anyone on the panel who would like to claim an exemption? If you would like to claim an exemption, please raise your right hand. Let the record reflect that no one on the panel is claiming an exemption. Now I will move to excuses. And with the excuses, I will not ask a series of questions. I will simply make 3 statements. And then based on the 3 statements that I make, if you'd like to claim an excuse, I would ask that those of you who would like to claim an excuse based on these questions, then we would ask you to come up before the bench. First statement is, a juror may be excused for observance of a religious holiday upon completing an affidavit as required by the Texas Code of Criminal Procedure, Article 29.012C. A person may not be excused for economic reasons without the consent of the parties. That is, you cannot be excused without the consent of both the defense and the state. And the last statement, a juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Is there anyone on the panel who would like to claim an excuse? Let the record reflect that no one on the panel is claiming an excuse, no one is claiming an exemption, and all the current members of the panel are qualified. Let the record reflect that the court is convened in cause number M325-296, case of style, the state of Texas versus Jorge Bo Gonzalez. And the time is 2:12 p.m. on today's date of October 20th of 2025. Again, ladies and gentlemen, good afternoon. You have been summoned to this court as a suspected juror in this criminal case. The defendant, Mr. Jorge Bo Gonzalez, who is sitting at the table, is represented by his attorney, Attorney Dustin Galmore. And the state is represented in this case by Assistant Criminal District Attorneys. We have Ms. Haley Simmons, who's sitting first chair. And we have Mr. Shane Hilton, who is sitting second chair. The court reporter is Ms. Adie Christie. She's sitting to my left. She will be taking down everything that's being said, so speak up when you are answering or asking questions. The bailiff in this case is Ms. Brenda Mosby. You met her earlier. The defendant in this case stands charged with the offense of driving while intoxicated. The state and the defendant, through their attorneys, have the right to direct questions to each of you concerning your qualifications, background, experiences, and attitudes. In questioning you, they are not trying to meddle into your personal affairs, but are trying to select fair and impartial jurors to hear and decide this particular case. It is very important that you answer these questions truthfully. If at any time you prefer not to answer certain questions in the presence of the panel, just say so, and I will ask that you will come up before the bench so that we can discuss the matter more privately. State, are you ready?
Thanks, Buddy Robert.
Defense, are you ready to proceed?
Yes, sir.
Okay. Ms. Simmons, the panel is yours. Give you 30 minutes. If you need more time, just let us know. We'll give you as much time as you need. And I will be keeping time.
Thank you, Your Honor.
Okay? You may proceed.
Good afternoon. Again. I always ask this question, it kind of hurts my feelings every once in a while, actually every single time, but who's actually happy to be here today? Show of hands. Anybody want to make me feel a little bit better? Okay, juror number one, thank you. You're the lucky pick. So here, my name's Haley Simmons, as I've previously introduced. You have Shane Hilton, and of course, defense attorney Dusty Galmore. Does anyone know myself, colleague, or Mr. Galmore? No? Does anybody know the defendant, Mr. Gonzalez? And show of hands, does anybody know Judge? I got a couple hands. I'm gonna start with juror number 13, Mr. Pouncey. Okay, how do you know Judge Holmes?
I used to work for this.
Okay, how long have you been away from Jefferson County? 9 years. Do you miss it? Is that why you weren't happy to be here today? Would that knowing Judge Holmes affect your ability to be fair and impartial in this case if you're selected? I need you to speak up. I've got a court reporter here that's gonna write down. Okay, and juror number, what number are you? 18, is it Mr. White?
White.
Okay, and you know Judge Holmes?
Yes.
How do you know Mr. Holmes?
Family friend.
Family friend? Would that affect your ability to be fair and impartial in this case?
No.
Am I missing anybody else? All right, I'm gonna kind of move along fast. 30 minutes goes pretty quick while I'm up here talking. So we're here for driving while intoxicated under Texas Penal Code Section 4904. What that means is a person commits an offense if the person is, drum roll, intoxicated while operating a motor vehicle in a public place. What's a public place, guys? It's a silly question, but I need y'all to know if you're selected as a juror. Can anyone give me an example of what a public place might be?
On the road, on the road.
Roadway, okay, one at a time, so my lovely court reporter can keep up with us. Juror number, was it 5? You said a roadway, juror number 19. Same thing,
Yeah, out in the public.
out in the public, everybody understands what that is. While operating a motor vehicle. Juror number 1, you're happy to be here. What would you say operating a motor vehicle would mean?
Driving a car, motorcycle,
Okay.
golf cart.
Golf cart, yeah, it does happen. Everybody understand what we mean by operating? Silly questions, I have to break it down, but of course the burden is mine, I need to make sure you all understand. So intoxicated in Texas. Does anybody know what intoxicated means? Under the influence? I'm gonna give y'all 3 fancy definitions, we're gonna go forward with today. Not having the normal use of mental faculties by reason of the introduction of alcohol and or drugs in the body. So juror number 2, I have mental faculties. I have that mental underlined right there. Can you give me an example of what not having the normal use of mental faculties might mean or suggest?
Yeah, not being able to think clearly or even see or hear clearly. But you normally
Okay, so you can't think straight. Everybody else understand that? Juror number 3, any other examples? Juror number 4?
Figure out your driving skills.
Like driving skills, would you say that's because you have to have divided attention when driving a vehicle? You have to be able to do multiple things at a time, right? So you need to be able to focus on turning the blinker on, taking that left turn, seeing that stop sign and stopping. Everybody understand that? Not having the normal use of physical faculties by the introduction of alcohol and or drugs in the body. Juror number 5, I think you know I'm kind of going down the line here. So you're up. What would be that?
Reaction time.
Reaction time? Well, when we think physical, what could be the loss of normal physical faculties?
Being able to step on the brake in time to
Okay.
stop.
Juror number, I'm skipping one, is it number 7?
Yes.
What would be the loss of physical faculties?
the visual acuity you can see.
Okay.
Something in the road.
The inability to see ahead of you? What about stumbling?
Sure.
Everybody agree? Can't walk straight. Everybody understand that?
Yes.
And lastly, having a blood alcohol concentration of 0.08 or higher. Y'all notice that or there on that number 2? Why do we have 3 definitions for intoxicated? Does anybody want to take a stab at that? Don't all speak at once, it's okay.
Your blood level, depending on your body composition, may be intoxicated at lower than 0.08.
So some people might react differently. Is that what you're saying? Who here agrees with that? A lot of you nods. Anybody not agree with that? So let's talk about that a little bit more, okay? I'm gonna introduce you to Lewis and Ogre. Has anybody met these fellows before? Do they look familiar? Okay, let's talk about Ogre first. I'm gonna read it out. I know it's a little small for some people, so. Ogre here weighs 250 pounds. He is a champion drinker by nature. He's been drinking since he started shaving at 16 years old, about 2 to 3 pitchers a day. Very high tolerance, normal use of mental and physical faculties. So those things that you all spoke with, he's not stumbling, his visual acuity, or he's thinking right. Those all seem to be fine. However, his blood alcohol content is over 0.08. I want y'all to remember all about Ogre, okay? We all got him locked out on our brains. Let's talk about Lewis. It's a little different. So Lewis here weighs 145 pounds, never had a drop of alcohol in his life until his wedding day. He decides to go and chug down 2 glasses of champagne. Speech is slurred, poor balance, inappropriate comments. Mental, physical faculties are not normal. He is stumbling. He's slurring that speech a little bit. Blood alcohol, however, is under a 0.08. Clearly doesn't have the normal use of mental and physical faculties. Show of hands, who do you think is intoxicated? Or let me ask, juror number 1, who do you think is intoxicated?
You would think one that was over, but using the definition it would be both.
You would suggest both, right? Why is that, juror number 2?
They in different ways meet the 3 qualifications.
Okay, you say they meet the 3 qualifications. Am I
One of them.
There you go. That or gets you there. Juror number, what juror are you? Fuck, you're counting, so am I.
8.
Juror number 9, is it Mr. Lowe?
Yes.
Who do you think's intoxicated here?
Both of them would be.
Both of them? Okay. Juror number 10, do you agree?
Yes, ma'am.
Do you even agree, even though Lewis there is under 0.08?
Yes, ma'am, because he's stumbling and doesn't have his balance.
So right there, you see the loss of normal mental and physical faculties.
Yes, ma'am.
So you think that would meet the element of intoxication, or one of them?
Yes, ma'am.
Texas law says neither Lewis nor Ogre should be operating a vehicle. Does anybody disagree with that? Does everybody understand why we have those 3 definitions? Any questions to clarify needed?
No.
How many of the 3 should the state be required to prove? I'm gonna move to, is it Ms. Hebert? Am I saying it right, or is it Hebert? Hebert. How many do you think I should have to prove? Of those 3 levels of intoxication?
I think just one.
Just one, that's right. Does anybody think that I'm required to prove all 3?
No.
No? Good, alright. Y'all are easy. Alright, who here has been around someone that was intoxicated? Show of hands. Okay, everybody, I got y'all's hands raised there. That's nice. Okay, juror number, I've already picked on you, but I'm gonna pick on you again. How'd you know they were intoxicated?
One of their eyes, one stay in, and one takes his part of the legal one.
Just, what did you see that made you think they were intoxicated?
Slur or speech.
Okay. Juror number 14, Ms. Menard? Stumbling down. Stumbling down? You knew they were intoxicated though, right?
Right.
Okay, juror number 15,
Yeah, just their behavior and their actions.
behavior and actions.
That's what normal,
Okay. So we all kind of understand that some things, such as smell,
Yes.
what about, my clicker's being crazy, speech, we talked about that slurred speech. Actions, your behavior, like you suggested, judgment, and balance. Everybody kind of following along? I know I'm moving quick, so I apologize. Who here knows someone that has been arrested for a DWI? Okay, one at a time. Keep your hands up. I'm gonna circle real quick. Raise them high for me. Juror number 1, juror number 3, 4, 7, 8, 9, 10, 11, back row, juror number 18 and 19. Okay. Let's see. Would that affect everybody that raised your hands? I'm gonna go one at a time. Juror number 1, would that affect your ability to be fair and impartial?
No.
Juror number 3?
No.
Juror number 4?
No.
Juror number 7?
No.
Juror number 8?
No.
Juror number 9?
No.
10?
No.
11?
No.
18?
No.
And 19. Okay, this next question, sometimes a little difficult, and I apologize. Like Judge said, you're more than welcome to speak with us in private if necessary, but we do want to inquire, just make sure you're a good fit. But who here knows someone that has been hurt, injured, or worse by the actions of a drunk driver? Show of hands. I've got 2, I've got juror number 3. And juror number 18. Did you want to speak about those matters in private? Okay, would that, knowing somebody that has been injured or hurt, would that affect your ability to be fair and impartial? No. Okay, so you'd be able to sit and listen to all the evidence before you?
Yes.
Okay. And juror number 18?
No.
Juror number, I think Ms. Hebert, you raised your hand thereafter. Did you want to talk about that here, or you want to talk in private?
It was something that happened long ago,
Okay.
before I was in the picture.
I absolutely understand. Knowing that, or whatever it may be, would it affect your ability to be fair and impartial in this case? You don't think so? Okay. All right, anybody else? What would you like to see in a driving while intoxicated trial to determine whether a defendant is guilty? Juror number 18, what would you like to see?
Want to see all the evidence,
What type of evidence? So give me an example.
I definitely would like to see the police report.
Okay, police reports, okay, what about body cam?
Body cam,
Okay, so you wanna see the video,
first report body cam and, also the evidence.
okay, all the evidence before you, juror number 19, what would you like to see in a DWI trial?
Well, like you said, the evidence and the police report and I guess the review, I don't know, I don't know what I'll be looking for.
You want me to put on a case, right? You don't want me to say, hey guys, we're here, but you wanna see evidence. Okay, juror number 20, what would you like to see?
I like they said, evidence, medical history. stuff
Okay.
like that.
Medical? Anybody wanna see something else? Is there anybody else interested? Juror number 8,
I wanna see the lab results from
the lab results.
either or blood.
So the blood alcohol consent, or content, I'm sorry. Anybody else wanna see that? Everybody wants to see that, right? Okay. Would it change your mind if it was a breath test? Would that bother anybody? Would anybody require me to provide a blood test over a breath test? You just wanna see the results, right? Okay, and you obviously all wanna hear from witnesses. Okay. Perfect, so we got witness testimony, which of course, you're a witness, you're gonna come over here and answer me and Mr. Galmore's question. Our questions, of course, are not evidence, but the answers are. Video recordings, like we talked about, body worn camera, dash cam maybe. Blood results from either a breath test or a blood test. CSI guys, throw it out of your mind, okay? Real quick. So, throw that out of your mind. Implied consent law. What I'm about to put up here, it is a mouthful. I'm gonna read it out just a little bit, but I promise don't freak out when you see all the words that come up. I'm so sorry, I can't really minimize that anymore. So if a person is arrested for an offense arising out of acts alleged to have been committed while the person was operating a motor vehicle in a public place or a watercraft while intoxicated, the person is deemed to have consented, subject to this chapter, to submit to the taking of one or more specimens of a person's breath or blood. Anybody understand what that means? When we get on the roadway, we are impliedly consenting to that. However, just because we're giving that implied consent every time we hit the roadway, we can't physically, or we can't compel somebody, they have the right to refuse to comply. However, effects of refusal, that can be considered as evidence of the issue on guilt. Does anybody have a problem with that? I know I went through that really quick. I know it was a mouthful. Does anyone have questions about the implied consent law? Does anyone know why we might have that? Want me to answer it? I will. Picture number 18. I saw your hand raising, but you stopped when I said an answer.
Most, for me. it's-
Okay.
I think it's, most time it's, some people, do it because attorneys tell you, don't consent to something, wait till you go to court. That way you don't have a lot of evidence. They try to
That's a
squash-
different story.
Sometimes they try to squash the evidence.
Okay. But can we all understand and agree that driving is a privilege and not a right?
Correct.
Do we all understand that? Does
Right.
anybody not agree with that? Perfect. Presumption of innocence, who here has it?
Everybody.
Everybody should be raising their hands right now. Okay, good. Everybody has it. What does that mean for me? It is my burden to prove every single element beyond a reasonable doubt. And what that means is every single element that I must check off. If I don't meet every element, you must acquit. If I do, you must find the defendant guilty. Does everybody understand the burden rests entirely with me? So let's talk about that. Burden, what does the defendant have as far as the burden go, the defense counsel? Do they have any burden at all? Absolutely nothing. Subpoena power, the right to discovery, right to trial, which is why you have all been summoned here today. I know y'all are happy about it. Right not to testify. Knowing this, would anybody hold the defendant's ability or right not to testify against him if he chooses not to? Perfect. Right to exculpatory evidence and the right to defenses. How do we treat each kind of witness? I'm gonna scroll through these real quick. I know the answer's on there, but juror number 7, here you are. How do we treat each witness?
Everyone's fine.
Everyone's the same. Would you require me to, or would you have an officer on the stand and hold them to a higher burden? Would you hold them to a lesser standard? Okay. Does everybody understand that officers, lay witnesses, all alike are to be treated the same? You get to determine the credibility thereafter. When they take the stand, they all have that same level of credibility. And then from there, if you're selected as a juror, you'll have the right to determine after their testimony if you want to believe all, little, or none. Everybody understand that? We're not to hold anybody to a higher standard. Reasonable doubt. This is where I usually say kick CSI out of your mind because you hear those crazy things like beyond a shadow of a doubt and all that nonsense. So Texas law requires the state to prove its case beyond a reasonable doubt. It does not allow me to give you a definition. I cannot do that for you, but we can talk about it a little bit. It's not beyond all doubt. If it was beyond all doubt, where do you think you'd be sitting? I'll give you a hint. Why would you be sitting right there? Anybody?
Seen something happen.
You probably saw it. You'd be testifying to what you saw as a witness in the case. Not beyond a shadow of a doubt, again, pick CSI out. Not beyond an unreasonable doubt. Best way to explain it, I'm sorry guys, you will know it when you see it. So when you came in and you put all your stuff in at the metal detector and you dropped your phone off and your keys off, I know you did not check off your common sense, and I need you guys to use it if you're selected as a juror. Does everybody understand that? Okay. So the jury's duty here is decide the facts, apply the facts to the law, and if you're selected, the judge is going to give you a charge with all the law provided. And then you're going to follow the law and you'll apply it to the case and then you'll decide. Does anybody have any questions for me? I know I talk a lot, so I'm sorry. Does anybody feel that they cannot sit on this jury and be fair and impartial? Does anybody feel that they cannot give this case the attention it deserves? All right, this is the last time I really get to conversate with you, so thank you so much for taking your time with me, and if you're selected as a juror, I look forward to presenting the case to you.
Yeah.
Who knows what happened? It died.
It died.
Do you have a charger?
No, I'm good. No, that's the charger, it's just not working. So I'll do it without PowerPoint. How's that sound, everybody?
Okay.
Not be fancy today. Give me a second, let me pull up majority of that. All right, so my name's Justin Galmore. I represent Mr. Gonzalez. I appreciate everyone coming down today and giving everyone your full attention. So I'm gonna repeat some of the things that you heard, and I'm gonna talk about some new stuff. Number one, if there's an allegation been made, okay, if Mr. Gonzalez has been accused of committing a drug while intoxicated, then really, why are we even here? Right, the police believe that he was guilty and the prosecutor believes that he was guilty when they filed the charge, then why are we even here? Mr. Wimberly, what do you think? Why are we even here?
Obviously, the facts need to be judged.
Facts need to be judged. Mr. White, Mr. Hill.
Yes.
What do you think about that? Why are we here if we've already passed those hurdles and the police think it was a crime committed or the prosecutor believes the crime was committed?
The way our system works, is you have the right to hear, your peers hear the case.
Mhm.
It's not automatic. I mean, we're not in a country that we live like that. Our rules are, and he's entitled to a fair, impartial trial, just like we all should be, all right?
Presumed to be innocent,
Yes,
right? Do the police ever get it wrong?
yeah.
Yeah.
We're human, we all make mistakes and we're all entitled to, doubt and question things.
I had a slide that showed an innocent person behind bars. Ms. Simmons, do you think that that's ever happened, that innocent people have been sent to prison?
Yes,
Why do you think that?
because it happens all the time, because the police do make mistakes, and there's mitigating circumstance that may show something to be one way when in fact it's another.
I guess you've seen that on TV or the news before?
Yeah, and my family and friends, yes.
Okay. What about the death penalty? Mr. Scroggs, do you think anyone's ever been given the death penalty and they were actually innocent?
Probably so.
It happens.
What do you think that feels like, sitting on death row for a crime you never did? Right? That's probably worse than committing a crime being punished for, it, right? So this is obviously not a murder case. No one's gonna get the death penalty. Does that mean that it's any less serious, you think? No? What'd you say?
Serious to him,
Serious to him, right?
be serious to all.
Criminal record's important these days, you think? Mr. Strong, what do you do for a living? Okay, had you circle city. Okay, you're a retired carpenter. Okay. Was the criminal record important to you, working for the districts that you work for? What do you think would happen if you got a criminal conviction while working for them?
I got a DWI, I lost my job.
You lost your job. So that would be important.
Yes.
Right. Miss, Miss Worsham?
Yes.
What about you? Are you an RN?
Registered nurses.
Okay, is your criminal record important to you? Yeah, you've got not only an employer, but you've got a licensing committee you deal with, right? So one of the things you heard about earlier is we protect people from wrongful convictions, even though I guess you can't always stop it from happening, all the time. It's a presumption of innocence. If you had to vote right now, based on what you've heard already, Mr. Gonzalez was guilty or not guilty, how would you have to vote? Right? Because he's presumed to be innocent. There's been no evidence, right? Right? So there's been an allegation, right? An allegation of driving while intoxicated. Who has to prove it? What does Mr. Gonzalez have to prove? Nothing at all. Miss Leonard? Leonard? Oh, sorry, what's too far? I'm trying to work my way that way. How about, Miss Hebert? Miss Hebert, what do you think? Do you think that a defendant should at least give their side of the story or at least show something?
I don't know.
You don't know?
I don't know if he wants to or not.
But as a juror, do you think that they should? Do you think that a defendant should do something or say something or
Be nice.
be nice? Who agrees with that? That a defendant, they should do something. They should prove something.
No, that's not rude, it's just, I talk to you.
Stop talking. Now, earlier, the state correctly pointed out that a defendant has the right not to testify, right? If they chose not to testify, since you would like to hear something, do you think that you would then weigh that against them? If they didn't say anything?
Probably not.
No. Anybody else that would like to hear from the defendant? And I mean, it's okay if that's the way you feel. I have a slide that I don't get to show. Anyone remember the Michael Vick story where he was charged with dogfighting? You got a big trouble for dogfighting, right? And there's a little funny little picture. It's got all these dogs on the jury. And Michael Vick sitting over here at the defense table, right? Would that be fair? Wouldn't be fair. So that's kind of why we're here today, right? We're here to talk about how we feel and there's no right or wrong answer to how we feel or what we think. It's just trying to find the right jurors. Mr. Walker, are you right-handed or left-handed? I'm right-handed. So if the judge instructed you, you had to be left-handed to serve on this jury, you think you could make that work?
Probably not.
Probably not. Wouldn't be a perfect juror for this case, would you?
No.
Okay, so you don't have to change the way you are, right? That's really the purpose of this, just kind of talk out loud and kind of see what we all think and see if we are, the right juror for this case. And so back to what I was talking about, who here, despite that there's an instruction not to hold it against the defendant to not testify, who here would say, you know what, they want to hear from the defendant, and if they're not gonna testify, it's at least just one little notch against them. Right? No?
It's really not a notch against him.
Okay.
Or really, it's not.
Well, good, good, that's the law in Texas.
Okay, it's not.
That's good, I'm glad we're all on the same page with that. Okay, so let's talk about blood, there was talk about blood. Let's say there was a blood test in this case, and let's say the blood did show a person was over 0.08. Why do you think that, and we allow a trial in that scenario? I'm gonna go to you, Miss, Worship.
It's the right to a trial.
It's a right to a trial, right? But is it a foregone conclusion if there's a blood test that shows you're above legal limit?
I have to hear everything. I want to
Okay.
hear everything.
Well, I hear
I see
everything.
that Holmes can. Oh, I cannot make a decision until I see all that.
Okay, you're a nurse. Do you ever deal with blood or blood testing?
I used to.
You used to?
Mhm.
Okay. Did you ever draw blood for blood testing?
For different diseases, yeah.
Okay. Were there any type of procedures or standards that you had to follow as part of drawing blood?
Absolutely.
Like what? Can you give me some examples?
Clean off the arm, use a fresh tourniquet, tell the patient what you're going to do it correctly, don't hurt them.
Why do you think that those standards are there? Like standards like you mentioned, cleaning the site and things like that. What do you think that's for?
Well, aseptic technique is a scientific fact. It's for patient's protection.
Maybe contamination,
Yes.
right? Who should prove if a blood test was done? Who should prove that it was done properly? Who should have to prove that to you? Ms. Worship, who should have to prove that to you? The state? What about you, Mr. Lowe? What do you think about that?
The state had approved the doctor, the law, somebody.
Does anyone disagree with that? Think that, it doesn't really need to be proven that it was done properly. Is that important? Mr. Pouncey, no, I'm sorry, Mr. Hebert, Mr. Godina. Is that important that the state would prove to you that it was done accurately and that it's reliable?
Yes, sir.
Let's talk about beyond reasonable doubt for a second. It is the highest burden in Texas or in any state that I'm aware of, maybe anywhere in the world. You've got a lot of burdens in criminal law, civil law. You've got probable cause, right? Everyone's heard of that, probable cause, pull someone over. You've got preponderance of evidence. Anyone ever heard of that? I've had some civil trial experiences in here, right? Some of you served on civil trials. Was that the burden that you had, preponderance of the evidence? Do you remember? Do some nodding, yeah. That's where you're fighting over money. Preponderance, the judge usually explain it to you as you've got two scales, if one's just a little bit higher than the other, well, then that's the winner, right? 51 to 49, I guess you'd say. Higher than that would be clear and convincing evidence. Anyone ever heard of that? Clear and convincing evidence? I guess it has to be clear and convincing, but if you're fighting over kids, CPS is trying to take, well, I guess that's the Department of Family Protective Services wants to take someone's kids away from them. That's the standard, clear and convincing. How do you think that should be, Mr. Godina? If the government's trying to take someone's kids, how high of a burden should that be? Should be very high.
That's your kids.
Probably a pretty big deal to the parent and the kid, right?
Sure.
So beyond reasonable doubt is higher than that. Judge is not going to define it. At the end, you're gonna get a charge, and there's gonna be all this law that's gonna look like this, and you're gonna flip over page after page after page, there's gonna be all this law in there, guess what's not gonna be in there? What beyond reasonable doubt means, it's not gonna be in there. In federal courts, they use a definition, that states, I need to get it, see, I don't want to say it wrong.
I'm gonna object to that, Your Honor. It seems to be misleading and confusing to the jury. It's gonna read the definition using federal court beyond a reasonable doubt.
Judge, this is not a definition that the court's gonna give, and it's certainly not a definition that the jury has to use, but it is a definition that the federal courts give. And the law does allow me to discuss it to determine what the beliefs of the jury is as to what beyond a reasonable doubt means to them.
Okay.
I've got a case site if you'd like to see it.
Yeah, let me see your case site.
Take a
You don't have it on paper.
It's gonna take me just a
You know,
second.
make sure you give it to the state too.
It's Fuller. Fuller v. State. Maybe 363 Southwest 3rd, 583. Let me
What
see.
is it?
Check and make sure that's the right citation.
When's it next one?
363 Southwest 3rd, 583.
363 Southwest Third.
I think that's it. I haven't pulled it up yet, but I believe that's correct.
Let me do this here. Miss Mosby.
Yes, sir.
I'm gonna take a recess. We're gonna have to do stuff.
Okay.
Okay, ladies and gentlemen, jury, we're gonna take a short recess. You can stand, you can go out either one of the doors, and when you come back in, you're gonna sit in the same seats that you're sitting in. Okay, so at this time, the court will be in recess. Everyone please stand as the jury, as the panel exits the jury, and everyone please stand. Okay, you may be seated. Okay, Mr. Galmore, the panel is yours. You may proceed.
Thank you, Judge.
You're welcome.
Appreciate y'all's patience. Just had to get some legal issues worked out. And so what I was saying before y'all walked out was that in federal court, they give a definition of proof beyond reasonable doubt. And what it states is that proof beyond reasonable doubt is proof so convincing that you would be willing to rely and act on it without hesitation in the most important of your own affairs. Okay? You would be able to rely on it without hesitation in your most important affairs. And so, I usually have some cool gambling slugs up here. Did I have a gambler in the courtroom? I'm not a gambler. I always lose, so I let it real quick. Well, let's just pick on you, Mr. White, because, I think you probably gambled before, right? You were in a casino? Mr. White? No, yeah, wait, 14, I'm sorry. I get the numbers wrong. Mr. Hill.
Yeah.
Mr. Hill, you're in a casino.
Yes, I have.
Okay, how important how important would it be to you to put $5 on red or black on a roulette table?
Yeah, I wouldn't do that.
You wouldn't do that? Too
No.
much money?
No, I just, I work too hard for my money. I just give it away.
I agree with you 100%. I'd rather buy a hamburger for that $5. What about you, Mr. Wimberly? What do you think? How important in your life would it be for you to put $5 down on a card game?
$5 is game of chance. You know, DraftKings.
There you go.
That's the.
But what if you were required to put half of your life savings on a 50-50 bet? Would that be important to you?
Extremely.
Extremely. That'd be one of your most important affairs, right? Your financial stability, right? How high of a burden would you want in that scenario before you feel comfortable that you're making the right choice on black or red?
100%.
Does everyone see how that works? The most important affairs, right? Your children, your money, your own future, criminal history, whatnot. Now the definition in Texas is no definition. So it's whatever it means to you is what it means. Mr. Holmes, I know you want to answer this question. Fine. What does beyond reasonable doubt mean to you?
Yeah, that I can sleep at night.
You could sleep at night. I like that. But you could sleep at night. What about you, Ms. Simmons? What do you think? What does beyond reasonable doubt mean to you?
It would have to be, an important decision that would impact me or someone else. Favorably or disfavorably. I'd have to feel that doing was in the best interest of either myself or that person. How would I feel? Do unto others as you have them do unto you.
Just like, what do you think?
That it's something that I can't see that it can go the other way. But I would be fully convinced that this is what happened.
Anyone else want to share what they feel like beyond reasonable doubt means to them?
10 years down the road, look back and say, yeah, I still the right decision.
Mr. Pouncey, you were a probation officer
Yes,
for how long?
32 years.
32 years. You had a little experience in criminal justice, right? What does beyond reasonable doubt mean to you?
To me, it's kind of strict prison for me, because I feel you're not guilty, but also you have to be able to see proof of this. So I would look at it like, did I make the right decision? Because a lot of decisions you have to always make, you know, for probation officer. So it would be kind of I look at the person to see their motive, and also I pay attention to how many times they had I've been trying to get UWI case.
Anyone else? Mr. Wimberly, let me give you a different bet. Let's say 50-50, black or red, 1 night in jail versus $1,000. Would you take that bet?
No.
No? No? Okay, let's move on. This is a kind of this would really be helpful if it was up there, so I'm sorry about this. I'm gonna have to explain it slow and then you'll just ask me if I need to say it again. I wanna make sure everyone understands them. But I'm gonna ask a two-part question. Okay, there's gonna be question 1 and question 2. And it's a scale. Question 1, if you believe question 1 to be true, you'll be a 1. And if question 2 you believe to be true, you'll be a 7. And if you believe it's somewhere in the middle, you'll be a 3. Does that make sense? I'm gonna use this as an example, Ms. Blackman. Question number 1 is, are you a male? Question number 2 is, are you a female? I'm assuming that you would say on a scale of 1 to 7, you would be a 7, right? You're number 7. You would be a female. Okay. I use that as just kind of an example. So here's the question. Do you believe, number 1, the first question, do you believe we are mostly the products of our heredity and our environment? Okay. Do you believe we are mostly the products of our heredity and our environment? That'd be a number 1. Or the other end of the scale, do you believe that the decisions people make determine their status in life? Okay, so the other end of that scale is we're not products of our parents and our environment. We are products of our own decisions. The decisions people make determine their own status in life. It'll be a 7. And you could be in the middle somewhere. Does everyone understand? Does anyone not understand? Okay. Let's just go down the list and you can just give me your number and I would write it down. That way both sides can just write it down. We're gonna spend a lot of time on that. What do you think, Mr. Wimberly?
7 would be for number 2.
7 would be you are in life based on your mistakes and decisions you made in your life.
I would lean more toward the first one, so 2.
2, okay,
4.
4,
Or
4, 4,
7,
7, 5,
right, no more.
right in the middle, 3.5. I like that. That's the other side of you. 4, 4, 4, 4,
3.5.
3.5, okay,
4.
4,
4.
4 is a popular number. 4, 4. Oh, I got off here. Let's see here. Sorry. Okay. Mr. Hill, you're a 4?
Yes, sir.
And then we jump to Mr. 18, Mr. White.
In the middle. Take the 3.5.
Okay, Gaines
4.
and Leonard.
4.
Okay. I think a lot of y'all just copied Mr. Holmes. You know? Okay, here's another question. Let's try this one more time. Are people's misfortunes often thrust upon them? Or do you believe that people's misfortunes result from the mistakes that they make? A little kind of the same, but not exactly the same, right? Number 1, are people's misfortunes often thrust upon them? All the way to number 7, people's misfortunes result from the mistakes that they make. Okay, let's just do that again. That worked pretty well, just going down the list.
Stay in the middle.
Okay.
3.
3,
6.
6, 4,
5.
3.5.
5,
3.5.
3.5.
Mr. Kelsey? Ms. Minner?
5.
Mr. Hill?
6.
Mr. White?
6.
Gaines?
6.
And Mr. Wood? Okay, all right, thank you very much. Let's change it up now. When it comes to raising children, how many parents do we have in here? Okay, I've got 2 girls, and I'm telling you right now, there's a lot of drama in my house. a lot of drama. When it comes to raising children, is it more important to have a child who, number one, is respectful, or number two, independent? Not a scale, 1 to 7. Okay, this time you gotta pick one. Is it more important, even if it's just a little bit more important, is it more important for a child to be respectful or independent? You just say one or two, independent. Number one would be respectful, 2 would be independent.
And at what age can they flip? Respect, one.
Okay, we got a 1.
All right, I got a 4-year-old. But. Yeah, I'll say.
Okay,
One.
okay. Okay, how about, are there any 2s? Okay.
You do both.
No, you have to pick one on this one. Even if it's just barely, preponderance of evidence, is it just a little bit more one way? Well, we got a 2, number 7. And we got a 2, number 8, 1.
No kids.
No kids, okay, so 1 and unknown. All right, Mr. Kelsey, in the middle,
I was gonna say both, but I'm saying one.
you're gonna say 1, okay. Miss Minner,
I would say.
okay. Any 2s on the back row or all 1s? 1, okay, all right. I want to know who agrees with this statement. I'm gonna give you a statement. Tell me who agrees with this. The police should be allowed to arrest and question suspicious people to determine whether they have been up to something wrong. Okay, the police should be allowed to arrest and question suspicious people to determine if they have been up to something wrong or illegal. Okay.
Arrest, no.
Okay, number 2? No.
No,
Okay, I will say, like you'll say, but, no, but.
oh no, it's a
Just
definite,
definitely,
hard no.
or no, okay. Does anyone think yes? The police should be able to arrest and question people to determine if they're doing something illegal. What about you, Mr. Johnson? No. Does anybody think they should?
This stands, I say yes.
Okay, that's, Miss Min. Okay, why do you think that?
Because it's better to, arrest someone if they feel that they're up to something. Later they can get released if they find out they're not.
I hear, who is that, Miss Simmons? What do you think about that?
We just said on this slide, and we know as human beings, police make mistakes. So arresting, and let's throw it out there to chance that maybe you did something. Well, now you done arrested me, I got a record. And then you prove later that I didn't do something, so that's a big inconvenience, it's embarrassing. It could even be dangerous. Cause when you're arrested, you go into the popo of the house, right?
Right.
You get hurt in there. Okay, so I don't think that should be just your independent judgment to, you look suspicious, so I'm gonna arrest you and we'll let the stuff fly. I mean, it's too much of that going on now.
Mr. White, what do you have to say about that?
We have a constitution
We do.
that, we should stand by all the time, so. If that's the case, all of us can be spent every day of the week. And just just because they look at you and say, hey, just arrest me. So we, under the law, we have constitutional rights, so. Everybody should have, we should stick to the rights of the Constitution.
Okay. Anybody else have a comment on that? No? There is an opportunity at the end of this, that if anyone thinks, there's something that I thought I was gonna get asked, it was something I really want to share. I think maybe y'all wanted to know something, but just it never came up. There's an opportunity to discuss it with the judge in private. Anything that we talked about, she talked about, or even anything the judge talked about earlier. Does anyone have anything that they would actually like to talk about with the judge in private? No? Okay, well, I really appreciate your time. I look forward to presenting the case to you. Thank you.
Okay. Okay, ladies and gentlemen, we're gonna ask that you go back out into the hallways, and we may call you back in, some of you back in for some follow-up questions. So at this time, the court will be in recess. Everyone, please stand as the panel exits the court. You could go out either side, either door.
Remember, I can't hold on.
Yeah, I got it. Sometimes this battery goes out.
Oh, yeah, so it's yours.
Okay, everyone, please stand as the jury, as the panel comes in. Oh, the panel, you could come in and have a seat. They standing for you. Somebody's missing 14. Y'all may be seated. Juror number 14 is not panel. Oh, that's just that. Okay. Jefferson County Court Law number 2 is back in session and calls number M325-296. Case is filed in the state of Texas versus Jorge Bo Gonzalez. Let the record reflect that Mr. Gonzalez is present in court with his attorney, Attorney Dustin Gilmore. Let the record also reflect that the state is present with Assistant Criminal District Attorney, Attorney Haley Simmons, and Attorney Shane Hilton. Let the record reflect that the panel is now seated in the courtroom. Ladies and gentlemen, if your name is called, we're gonna ask that you come and have a seat in the jury box. There are some tags on the top counter. Please take one tag, and when you get into the jury box, pin it on your clothes. At this time, we will have Ms. Linda Segura, who is one of our court coordinators, and she's going to call the names. Ms. Segura?
James Holmes,
James Holmes,
Troy Frost, Weston Walker, Stacy Worsham, Brennan Gadina, John Hill, Eddie White.
Okay. Okay, ladies and gentlemen of the jury, I need to administer to you the second of the two oaths that I previously mentioned. So at this time, I need every one of you to raise your right hand, and when I finish administering the oath, please say I do. Do you and each of you do solemnly swear or affirm that in the case of the state of Texas versus Jorge Bo Gonzalez, that you will a true verdict render according to the law and the evidence, so help you God? Okay, you may put your hands down. Members of the jury, I will give you some instructions and a general idea of what to expect in this case. Every case is composed of facts and the law as it applies to the particular case. The facts comes from the witnesses on the witness stand. The law comes from the statutes, codes, rules, and other court decisions interpreting them and how they may apply to this case. You and I have equal authority, but it is divided authority. You are the sole judges of the facts of this case, and I'm the sole judge of the law. You are the sole judges of the credibility of witnesses and the weight to be given their testimony. You can believe all of what a witness says, part of what a witness says or none of what a witness says. As the trial progresses, the attorneys will probably make objections to questions asked by the other attorney of witnesses and objections to the introduction of documents or objects. This means that in the objecting attorney's opinion, there's a legal reason why the testimony or document or object should not be received by you. Sometimes I will simply sustain or overrule the objection. At other times, it may require lengthy discussion outside of your presence. If that happens, I will either ask you to step outside for a few minutes or ask the attorneys to come up to the bench so that you cannot hear the discussion on a point of law. The reason for that is, as I told you earlier, you are the sole judges of the facts you receive, and I'm the sole judge of the law. I can't be with you in the jury room when you deliberate the facts. Therefore, you can't be present or within hearing when I deliberate questions of the law. The reason why I will sometimes ask you to step outside is simply because this is the most efficient way to do it. Otherwise, if we were to leave the courtroom, the court reporter would have to gather her equipment and take it with her, and the attorneys would have to gather their files, etc. The rulings I do make on questions of law in your presence are not evidence, and you are to disregard them. After all the evidence is in, and both the state and the defendant have rested their cases, the court will prepare and submit to you a written charge containing the law and instructing you on the law in this case. We will then hear oral arguments from the attorneys. The attorneys have the right to make a summation of the evidence and to make reasonable inferences or deductions from the evidence. Since the state has the burden of proof, it has the right to open and close the summation or argument until you retire to deliberate. Do not discuss this case amongst yourselves, and under no circumstances should you permit anyone to discuss this case with you. Do not attempt to learn from any source outside of the courtroom anything about the facts of this case, nor attempt any independent investigation on your own. Don't visit the scene involved in the facts of the case. Don't read any reports in the newspaper or watch television, and don't even consider anything that you see on social media. Do not make up your mind about this case until all the evidence is in and you have been instructed on the law. Don't take notes during the process of the trial. Don't visit other courts during a break if a trial or other proceeding is in progress. The badges that you have, you'll be allowed to take those badges home with you. And please wear those badges when you come to the courthouse, because those badges identify you as a juror in County Court at Law number 2. Ladies and gentlemen of the panel, I'd like to thank you for taking time out from your busy schedules to be here this afternoon. I know some of you may be disappointed because you took time out from your busy schedules to be here. I'm gonna pretend I didn't hear that. And so, a lot of times people come to court to serve on the jury, and they think when they don't get selected that they wasted their time. But, you didn't waste your time, because as I mentioned to you earlier, before you even arrived here this afternoon, we were at work on cases starting at 9 o'clock this morning. We had a jury trial docket, and some of those cases was moved. And the reason why it was moved is because they knew a jury was going to be showing up here at 1:30 to try those cases. And so your presence here helped this court and the courts in Jefferson County to move its docket. And so I'd like to thank you for taking time out from your busy schedules. Now, I know that when you came here this afternoon, you probably looked over the top of the door and you saw that it's County Court at Law number 2, Judge Terrence Holmes. And you probably said to yourself, you know what, I'm in the right place. This is Judge Holmes' court. Well, this is not my court. This is your court. This court is the court for the citizens of Jefferson County. I'm only a public servant here in Jefferson County. So I said that to say this. Anytime that you're in the area of County Court at Law number 2, you can come and have a seat in your courtroom. In fact, you can sit in that area that you're sitting in. We call that the peanut gallery. But it doesn't mean you could bring peanuts in here and eat, because this is not the Texas Roadhouse. But you can come and have a seat in your courtroom and see what goes on in Jefferson County. And I know that you'll find it very interesting. Now, our bailiff, she have some letters for you. If you feel like it, just please drop us a line and let us know about your experiences here in County Court at Law number 2. Now, before you leave, I usually give handshakes, but we still have COVID in our community. However, I like to give each and every one of you what I consider a call an air handshake. And so, on behalf of the citizens here in Jefferson County and behalf of the staff here in County Court at Law number 2, thank you for coming out. Your jury services has ended. If you need anything from the county clerk's office, the district clerk's office, they're right across the hall. Again, thank you for being here, and every one of you have a blessed day. You are excused. And just for a reminder, if you would like to, this court is going to reconvene on this trial tomorrow at 1:30. You can come and have a seat in that area if you want to watch it, or you can watch us on YouTube, whichever is convenient for you if you have time. Thank you. Okay, we're gonna start back at 1:30, is that
Yes,
correct?
sir.
Okay, ladies and gentlemen of the jury, we're going to start back with this case at 1:30 on tomorrow. And just to give you a little overview of what to expect on tomorrow, when you come back tomorrow, the state is going to read the charge. It's an information that we call, in felony courts, they have an indictment. In misdemeanor court, they call it an information. It's just a charging instrument. And so the state is going to read off the charges. The defense is going to state his plea to that charge. And then after that, the district attorney, as well as the defense, may want to have an opening statement. The defense may want to reserve. But after that, then the state will present its case. They'll call their first witness, and then the case will proceed further. Okay, so at this time, you're excused. And when you come back tomorrow, make sure that you have a seat right out in the hall outside of County Court at Law number 2. And then when we're ready to proceed, the bailiff will come and get you. Okay, so at this time, you are excused. Everyone, please stand as the jury exit the courtroom. Okay, the court will be in recess until 1:30 on tomorrow.
Thank you, Your Honor.
You're welcome.
Swap.